As Council will have observed, Lord Sales is having to join us remotely. I hope the technical problems have been sorted out, and I'm sorry about the delay, but we'll try to make up time.
My Lord, thank you. My Lords and my Lady, I appear in this case for the appellant with my learned friend Miss Hutton for the Council. My learned friend Mr Humphreys appears for Symmetry, and my learned friends Mr Honey and Mr Streeton appear for the Secretary of State. In a nutshell, my Lord, in some cases it may be reasonable to consider that the provision of highways, that is, ways which are open to the use of the public, is required to make a developer's scheme acceptable in planning terms. Connectivity between places is often a vital part of the public realm and of good planning. This case is a paradigm example of where a scheme required with it the provision of highways. In those circumstances, my Lord, it is reasonable for the developer to be expected to provide the highways to make their scheme acceptable. It's not for the local authority to have to provide the highways for the developer and compensate the developer for the land involved in doing so. The lawfulness of such conditions is governed by the Newbury tests, and I would add that in this particular situation, the approach to lawfulness and particularly relevance is the same in respect of planning conditions as to the relevance of planning obligations requiring the same provision of highways to the grant of planning permission. The Court will have seen the facts. I want to just draw attention to a number of the factual points before going into issue 1. The Court will have seen that the illustrative landscape master plan, which is at page 258 of the bundle, shows roads coming in from the north from the existing A420, but also coming out new to the east and to the south into other development areas. Those are substantial, they're labelled as carriageways. We also see footpaths and cycleways. The Design and Access Statement Addendum number 2, which is one of the developer's documents submitted to the planning application, page 260, paragraph 4, says the illustrative master plan has also been amended to show highways extending to the site boundaries. These show the east-west route and north-south route extending through the site and into adjoining land. The context the Court can see from the committee report. Now, that's not, I should emphasise, relevant to interpretation, because the Planning Permission is not ambiguous, but it's relevant to the rationality of the condition that's imposed. And what the committee report shows is that this is part of a wider scheme known as the New Eastern Villages. And what is essential with that is that there is connectivity between the particular parts of that, so that people who live in the new residential development will be able to get to the employment areas, for example, and that the employment development is then able, people in there are able to travel not simply to the existing road to the north, the A420, but also to travel through the New Eastern Villages. And the Court will have seen the references we've given for the later note, paragraphs 29 to 33, 65, paragraph 93.
Sorry, what are these paragraphs of?
paragraphs 29 to 33, which is at start at page 270, my lady. Paragraph 65, which is at page 278. Paragraph 93, which is at page 285. And one other illustration of the connectivity that's required, and we see it in the planning obligation as well, is that the symmetry scheme is expected to make financial contributions to other road improvements elsewhere, so off the symmetry site. And these include the Southern Connector Road, which is a road coming in to the New Eastern Villages from the south. And the court would appreciate the references to that in the committee report are at 279, paragraph 68, and the contribution to the Southern Connector Road is in the planning obligation itself. Clause 1.1, which is at page 305, and then in Schedule 2, paragraph 13. So the scheme was put forward and envisaged as something that's interconnected. The developer refers to the provision of highways, and that is something which is necessary in the council's view. It is relevant. Present purposes, it is a reasonable and lawful view that the scheme should provide that degree of connectivity, that people, whether coming from within the New Eastern Villages or simply travelling through those, would be able to use the access roads which are within the symmetry development. Can I turn then to issue 1, which is whether a planning condition can require the dedication of a highway. And the legal tests on lawfulness are those set out by the House of Lords in Newbury, that a condition must be for a planning purpose, it must fairly and reasonably relate to the development permitted, and it must not be Wednesbury unreasonable. Usual reference in Newbury is to Viscount Dilhorne's speech, which is in our bundle page 862H, paragraph 5, page 599 of the report. The Newbury approach has been confirmed by this court recently in 2 decisions. The decision in Aberdeen, speech of my Lord Hodge, at paragraphs 28 and 32, which is at page 603 of the bundle.
603?
603. And then most recently in Wright, with the speech of Lord Sales at paragraph 34, which is bundle page 1031. The application of the Newbury tests is fact-specific. And that was a point made quite correctly in the High Court by Mrs. Justice Andrews at paragraph 37 of her judgment. And there is a spectrum of potentialities, and that is what perhaps it's worth having in mind when we come to think about Hall and Shoreham. On one side of the spectrum, which is our side of the spectrum, a developer's scheme may require highways to be acceptable in planning terms, so that it needs to be providing through roads so you can go through that scheme onto perhaps other land which is due to be developed, providing ways through, both in terms of vehicles but also on foot and on cycle. If a court envisages urban life, or even for that matter village life, it is most of the time about having the ability of the public to pass between spaces and pass between places, to go through that. Not development which is simply a gated estate. Not development which is simply cul-de-sacs. Obviously there are gated estates, obviously there are cul-de-sacs, but there will be circumstances where the planning authorities will consider that that's not appropriate. The question then is whether it is reasonable, in the light of the Newbury tests, to require that the access is given. Conversely, of course, the other end of the spectrum would be the situation where the desire for the road arises not as a requirement of the scheme which the developer is putting forward, but because the public authorities would like to have the road for wider and different and general interests. Now, there's no great difficulty in that situation in both the Secretary of State on an appeal and the courts, if it comes before them, taking the view that it is not lawful for the local authority to impose a condition requiring the developer to build a road. It may be that in those circumstances, it simply doesn't fairly and reasonably relate to the development which is to be permitted, that what the developer's application for. It may be quite irrational to require that to be done. But how the lawfulness of such a condition requiring highways is to be determined on a fact-sensitive consideration, as all considerations of irrationality are. Now, in this case, there has been no challenge to the rationality of saying that highways are required to make the scheme acceptable. It's a perfectly reasonable view for the authority to take, one might say, the obvious view. So the condition, as we interpret it, I'll come to interpretation on issue 2, of course, is one which meets the Newbury criteria and is rational and is lawful. The second point I want to deal with under issue 2 is whether there's any issue on statutory construction which prevents a condition from requiring highways to be provided. And the answer to that is no. Section 70 of the Town and Country Planning Act, which is at page 1319 of the bundle, allows authorities to impose such conditions as they think fit. Section 72 allows authorities to impose conditions on land which is outside the application site, but which are in the ownership or control of the applicant and is nearby. The significance of Section 72 is not that we're dealing with a land that's outside the application site. The access roads are well within the application site. But that what Section 72 does is to say various things which those conditions can require, and that includes regulating the use of land. A requirement to provide highways, so ways accessible to, open to the public, as regulating the use of land. I don't need to...
Is that right? I'm just wondering about it. If for example, you have a house, as a lot of older houses in London are on streets which are not highways, but are private roads. The householders might decide to have the road made up and with the view to its being adopted by the highway authority. Will it require planning permission?
No, my lord, the only planning permission that might be required would be for the carrying out of the works, but those would probably have permitted development rights.
Yes.
Doing so.
Yes, because the use wouldn't change.
But the regulation of the use, the question of what is done in this particular, in the particular case we're dealing with here, the regulation is that the requirement is to allow the public to use it because it is to be a highway. So it's a control of use or control of restriction.
I'm thinking about the first of the Newbury conditions, that the condition has to have a planning purpose.
Yes,
and I'm just wondering if requiring a road to be a public highway rather than a private road is something which can be said to be for a planning purpose, because the use of the land is the same in either scenario.
Well, the use as in planning terms is the same, but the use in terms of whether it's a material change of use.
I know. In ordinary language, you could say there's a difference in the use of general public are entitled to use it or if they're not. But in planning terms, the use doesn't change.
Well, my lord, not in terms of where it's a material change of use, but in terms of meeting the planning purposes. One of the planning purposes are about the development and use of land. And that will include the question of how people get about within that site and between that site and elsewhere. That has implications both in terms of what one might describe as urban design and livability, the question of how it fits into its context, how people use it. It also has implications in terms of transport and the impacts on the rest of the road network. So to move to the situation we have here, we have a planning permission which shows 3 roads exiting the site. One of those is to the A420, to the existing highway to the north. The other 2 are to proposed development areas. Transport movements to and from the Symmetry site will be affected by whether or not vehicles are coming and going simply from the existing A420, or they are coming and going from the south or from the east through the new roads. So in terms of assessing what the impact of the scheme is in transport terms as well as in other terms, you need to know how those roads are capable of being used. So, for example, whether traffic elsewhere in the eastern villages is going to be going through them or not. So, my lord, those are all highly relevant to planning.
I mean, I think that you accept that Condition 39 does require you to construct the roads to a highway standard, and that's what DBS say it's limited to. But I'm not quite sure from your answer whether you're saying that there are likely to be some people who won't be able to use the road if it's not a public highway. For example, it wouldn't be able to be used as a bus route unless it's a public highway, or lorries won't be able to go on it. But what will be the difference in terms of who is able to use the road, depending on whether it's a public highway or not?
Well, my lady, if it's not a public highway, then Symmetry will control who may use it. If it's and they may simply restrict use to access to and from the units within it. If it's a public highway, it is then not open to everybody to use, but more importantly, in this context, will be able to connect in with the land to the east and to the south.
It can be used as a cut-through by people who want to get from one area to the other.
Well, it becomes a route, and cut-throughs, perhaps, I'm not sure.
It's a new road.
It's a new road. It's a new way into the whole of the new eastern villages. So it becomes a way to go through the Symmetry South to go south, and also links in to the east to further development, which is envisaged there, which is south of the A420, but east of the Symmetry site. What is envisaged, to take my lady's question about a bus route, is an express bus route. And of course, the ideal of a bus route is that the bus route goes through a site rather than to sort of turn into a cul-de-sac, drop people off, pick people up, and then sort of go back out the same way, which is not so much a problem for the people who are coming to and from the Symmetry site, but is a delay to everybody else.
So is the planning purpose to facilitate the development of the adjoining sites to which the roads could provide access?
It's to facilitate the proper movement of vehicles and people through the new eastern villages. Part of that, my lord, is to help facilitate the other developments.
But it can't be required to facilitate the development of the site itself, because obviously if a developer, as you say, is entitled to control the use of a road if it's a private road, but he'll control it in a way which enables the development to be a successful development.
Well, my lord, it's needed facility because, in terms of the use of the Symmetry land, it's envisaged that vehicles going to and from the Symmetry land will not simply be coming in from the existing A420 junction, will be using the other routes,
yes,
including down through the new eastern villages to the Southern Connector Road and so on. So what's envisaged is for the Symmetry scheme to be working properly, that people are coming to it from those three directions, and also that the rest of the new eastern villages are able to go through the Symmetry site to move around. What is not acceptable to the local authority is for the Symmetry site to be a cul-de-sac.
Yes, and that's because they are wanting to open up access, or connectivity, as you put it,
yes,
with the surrounding areas of land that have either already been developed or are programmed for development.
Yeah. Yes, my lord.
And presumably, the council would intend to ensure that when the other sites are developed, that there are roads through which will be public highways, through which people will be able to travel onto Symmetries.
Yes, my lady.
And are those likely to have other junctions with the A420?
There's one other junction envisaged with the A420. If the court has in mind page 258, I'm afraid we're not... but 258, which is sorry, I apologise, 256, which is the general location, and as against that in mind, what we were at 258, the illustrative master plan, the intention is to have another junction with the A420. The A420 runs roughly east-west across the top of the site. Another junction further east, the A420, and then the Southern Connector Road comes in to a roundabout near, if the court looks at the the green A road, which is A419 coming down, Southern Connector Road will join in to a junction near there, just to the left of where it says Wanborough. So there will be a number of routes running through.
There'll be a road branching off from the A420 down to join the A419 near Wanborough.
Sorry, the A420 runs roughly west-east, just to the north of the site location. The A419 is the greeny-yellow route running south.
And the eastern villages are lying to the just to the east of what is marked as the site location.
Yes, there'll be a new access to the A420 to the east of the site location. That's right. And then the other main route into the new eastern villages will come just to the left of where it says Wanborough. Of course, it's perfectly conventional for developers to provide highways which then become adopted as part of their schemes, both in terms of situations where the highway we need it to be a highway because it's going to be a through route, or in situations where the developer chooses to construct it to highway standards and then to be adopted, as tends to be the case, for example, with a residential estate, that it wouldn't be kept as a private road. The critical point here in terms of the conditions and the application of Newbury is you have those situations where it is in the interests of good planning, as far as the planning authorities are concerned, that highways are provided. So we avoid a situation of, here, for example, the new eastern villages, of really being a collection of large cul-de-sacs, which aren't interconnected. You can't, if you live in a residential part, you have to go a long way round to find a way to get into the employment area, rather than simply being able to drive or walk or cycle a fairly direct route to it. And that's why it may be rational in planning terms to require the provision of highways. And to go to the point I was being asked about, that is part of regulating the use of land, regulating the control over who can go onto the land and who is able, to what extent the developer is able to restrict access to the land. And that element of a condition preventing the landowner from restricting access is a point which was accepted, so the condition can do that, was accepted by the Court of Appeal in Hall and Shoreham. And I'll turn to that case now. The facts are worth having in mind that this was a site adjacent to a road which had an overload language at the time of traffic on it. The development would add to it. The local authority, but not the developer, wanted as an ancillary road, or what was called a secondary road, to be constructed through the various plots of land alongside the existing road. And it's imposed a condition requiring that to be done. But, and this is undoubtedly a factor in how the court would have been looking at it, the whether an ancillary road was to be constructed or when was to be at the dictate of the local authority. So at an uncertain time in the future, no doubt relating to the ability to impose other conditions on other plots of land. The new access was to be allowed for at least 5 years. So the developer had a scheme which was considered to be acceptable as it stood, even though it would contribute to traffic, but at some point in the future would be required to construct another road. Now, the way in which the Court of Appeal dealt with it was, first of all, to recognise that a planning condition could require a landowner to allow access across its land. And the references to those are the judgment of Lord Justice Wilmer at bundle page 744, bundle page 774, and Lord Justice Harman at bundle page 783.
It recognised that planning condition could require
a landowner to allow access across its land. So the concern of the Court of Appeal in Hall wasn't the restriction of the landowner's ability to exclude somebody from their land. They thought that a condition could require access to be given to neighbours, but the concern was that a condition which, in effect, required a highway because it allowed access to the public would be doing something which the public authority ought to be doing if it wanted it by compulsory purchase powers and to pay compensation. It's the dodging of the compensation which was the trigger behind how the court looked at it. But it's worth having in mind that in our present case, my learned friends explicitly in the context of symmetry, and the symmetry written case, disagree with that notion in Hall that a condition could require the landowner to allow access across its land. So it's the symmetry written case, page 165, paragraph 72, and then 167, paragraph 80, and it seems to us to be necessarily implicit in the Secretary of State's case that conclusion, the condition could restrict access, was not correct, seems to follow from 189, paragraph 15F of the Secretary of State's case, but I'm sure we'll hear from my learned friends on those. The concern of the Court of Appeal was provision of a highway without compensation. Whether that was a correct concern depends on the facts of the case, and the difficulty with the Court of Appeal's reasoning, this is where they go wrong, is to have stated that as a matter of principle. Now, go back to my spectrum. If the road, the ancillary road, is simply a desire of the local authority because they think it's a good idea to have an ancillary road, but it's not required by the development which is being proposed by Hall, then in those circumstances the Court of Appeal was quite entitled to take the view that it would have been irrational to have required the road to be provided. And of course there's a hint of that given the uncertainties of when that would be sought. If the ancillary road was necessary for the purposes, or reasonably required because of the Hall development, then applying the rationality approach, entirely reasonable to require that and to require the developer to pick up the costs and for the developer to do it rather than to expect the public authority to do it for them. And in a sense, my Lord, that is behind quite a lot of the useful analysis of Lord Hoffman in Tesco. Its analysis that's entirely over to the question in Tesco was whether a planning obligation which funded a major road was either a material consideration. If it was a material consideration, was the Secretary of State entitled not to attach weight to it? So it's a case about planning obligations rather than conditions. But as the court may have seen, Lord Hoffman in a speech, which is oblique, it's not important, and also it's not one which his colleagues dealt with, discussed how the use of planning obligations had arisen. The principal observation for relevant purposes being that the Hall case had discouraged the use of conditions, and so then planning agreements and obligations were being used to fill the gap. But what Lord Hoffman said was that...
Could you just give us the reference? Then we can...
reference in the Tesco judgment is in the authority, in the bundle, my Lord, 1138.
Thank you.
So in the report 771H onwards. And his emphasis was that the court sort of construed the ability to use conditions narrowly, not because of the general principles, what we now call the Newbury tests, but because of the way in which these principles were applied to the facts of particular cases. He makes that point in our bundle at 1139, 772D. And he observed that in Hall, there was no recognition by the court of the possible justification. That's at page 1140 of the bundle, 773B, which is the extent to which the Hall scheme contributed to the need for an ancillary road. Now, my Lord, we say in respect of Hall, it could have been justified on its own facts. We don't have to, and this court doesn't have to conclude that Hall was wrong to quash the condition, ultimately the permission, but that was then a matter of judgment about whether it was rational, given particularly the delay and uncertainty about whether the ancillary road would be required to impose such a condition. But that to make a general statement that a road, a highway could not be required because that ought to be procured by the local authorities under their powers and pay compensation, was wrong. What the Hall approach does in those situations is to avoid the developer from picking up what Lord Hoffman refers to as the external costs. What is needed to render their development scheme acceptable? And if what is needed to render it acceptable is to provide highways, then it is rational for the developer to do that. It also puts the developer in a situation of being beholden to the highway authority as to when and whether the highway authority choose to provide the highway. Now, if that is necessary for the scheme to proceed, then of course there's a problem that either we get to the same effect of the condition being imposed saying the scheme can't proceed unless the highway is provided, or permission is refused because there is no highway and no certainty as when that would be in place. Now, of course, in practice, that tends not to happen because because it is recognised that highways may be required and recognised that the developers have to go to the trouble and expense of providing them if they are required for their scheme. And that tends to be done by planning obligations, but it doesn't have to be done by those. Planning obligations, as the court will have seen, are made under Section 106 of the Town and Country Planning Act. For the note is at page 1338 of the bundle. An obligation has to be made for one of the four statutory purposes, and those include restricting or requiring use of the land which is subject to the obligation. For those purposes, there's no difference to regulating the use, which conditions can be. It's saying what should or should not be allowed to take place on land.
Can I just ask, in the case of the planning obligation under Section 106, is there an arrangement made as to the maintenance of the road? Is that addressed in 106 1D? How does that work as a matter of practice?
In practice, Section 106.1d, which is the ability to make a financial payment to the local planning authority, is generally used for off-site contribution, so for the construction of roads elsewhere or provision of open space elsewhere. It will sometimes be used for the making of payments for the maintenance of open space on the land, if the land is to be, for example, transferred to a parish council rather than being maintained by an organisation related to the development. In that situation,
Can I put it the other way around then?
Yeah.
How is the arrangement normally made for the maintenance of the road in the case of a Section 106 obligation?
normally what would happen if you're dealing with the maintenance of a road, which is a highway, which is intended to be a highway, is that ultimately the developer, once that's provided, will actually seek to have the highway adopted by the local highway authority or other highway authority under Section 38 of the Highways Act 1980.
Yep.
So a Section 106 agreement may require there to be a highway. It may, incidental to that, require the transfer of land. So, and that arises not actually from 106D, which is the financial provision, but from either 106A or 106C, which relate to development, character works, or the use of the land. So,
as a matter of practice, the relevant authorities then cooperate, do they, to ensure that the highway is properly maintained by the highway authority?
yes, once it's adopted, the highway authority will have to maintain it.
Yes. The adoption first of all, and then subsequently, I suppose, inevitably.
Then subsequently it falls on the highway authority, and the highway authority, before adopting, will want to be ensure that the road has been properly constructed. And there's quite often, under Section 38 agreements, a period, not only a supervision of the build, but also a period between the road being brought into use and then its actual adoption, so the highway authority can see that it's actually performing quite well and it's not deteriorating quickly.
Thank you.
It's possible in the Section 38 agreements for financial arrangements to be made for a contribution to the maintenance being made by the landowner, but that's not always the case in those situations.
Thank you.
But the ability to require highways and, as incidental to that, transfer of land under Section 106, which is what is done in this case, where there is a proposed enlargement of the existing A420 at the north, dealt with by Schedule 2 of the 106, that arises from the power in 106A or C in relation to works and to the use of the land that's the subject of the planning obligation. So the transfer of land there is incidental. We're not here
What do you mean, the transfer of land?
Yes, I was wanting to ask you about that. What do you mean by that?
But
In what sense is the land transferred?
and under condition 39, the land is not transferred.
No, you were talking about planning obligations. I can't see at the moment that it can require the developer to transfer ownership of the land to someone else, but you're saying that they can do that?
They can do. It is dealt with as a matter that's incidental to the restriction on the use of the land.
And when a Section 106 planning obligation requires the developer to dedicate a road to be a public highway, does that always, sometimes, never involve the transfer of ownership of the land to somebody else?
It may well do, and for example, that is actually done on this planning obligation in respect to the A420 junction works, that it allows the local highway authority to call for the transfer of the land to enable those works to be carried out by it. But it is...
But if you're requiring the developer to carry out the land, does it, at least when the land is adopted by the highway, does the transfer of ownership to the highway have to take place then, or does it usually take place?
It will vary. The effect of adoption is that, in principle, is that a highway authority becomes the owner in respect of the two spits of land, in terms of the part of the land that's required for its status as a highway, and any ownership of the subsoil would remain with the landowner. A planning obligation could require the transfer of the whole of the land interest in relation to that.
So when a highway authority compulsorily purchases land to make a highway, do they then just buy the surface of it or the subsoil as well?
No, my lady, they will acquire the subsoil. They'll acquire the whole of the interests in the land if it's a compulsory purchase.
Is there? Can you point us to a statement where we can see the effect of adoption by a local authority, by agreement, of a road giving rise to a transfer of ownership?
Well,
of anything, you know.
Yeah.
I'm talking not just about the subsoil, perhaps simply of the top layers of the top road.
It's the issue that's we'll check for the best references to that, but it's the issue which was debated by this court in Transport for London and Southwark as to what the extent was of, in that case,
that's right,
the question of what the highway authority's ownership was, as in the vertical plane, as how far up and how far down it was. But that's a relation, the court may well recall some of the issues in that, but that's in relation to the ownership rights which it has as highway authority, as distinct from any other, from the ownership of the subsoil. But there's an ownership right which comes...
Wasn't it, with it was things like disused lavatories that were underneath the roads had turned out to be valuable as potential nightclubs and the like. If memory serves.
I focus on what it says about what's a highway rather than why two London authorities were slugging it out over why it mattered. But so that transfer of the ownership, but that arises for the adoption of a highway by the authority, by the highway authority, it doesn't arise from the creation of a highway. The creation of a highway itself doesn't give rise to
I was
highway
asking
authority ownership.
Authority on the effect of adoption, and you pointed me to TfL. Thank you.
So,
He was just saying the creation of the public highway before it's adopted doesn't require any transfer of ownership from the developer.
no, my lady. It doesn't alter ownership. It's the dedication, the acceptance of the use of it by the public, which gives rise to the public right of use of the highway. But land transfer is well known as incidental to the restrictions on use of land. That's the rationale under a planning obligation. So it is quite common for planning obligations to require the transfer of land to an affordable housing provider, for example, or open space may be transferred to either a management company or transferred to the parish council, for example. But here, in terms of conditions, we're not concerned with transfer of land. It's simply the dedication of highway rights that follow from it. But the use of planning obligations to require highways in connection with development schemes is something which is to be judged in relation to a planning application the same way as part of the Newbury tests. If for an authority to say that we will not grant planning permission unless a planning obligation requires provision of highways, for example, that obligation must be material. And as this court has considered recently, materiality is judged by the Newbury test. That's the decision of this court in Wright. I've given the reference before, but it's paragraph 34 of Lord Sale's judgment, which in the bundle is 1031. So in both respects, we're looking at the rationality in a fact-specific context. And another example of the court taking the view that what would be irrational in a planning condition would be irrational in a planning obligation or planning agreement is in the decision of the Court of Appeal in Bradford, page 632. Now, there is a difference which is important on planning obligations, as we've discussed, which is the ability to require the payment of money, which is not possible in a condition. But there is an overlap between those conditions and obligations can often be used for the same things. Sometimes the condition power is wider, can control what happens on land outside the application site or outside the land under control. In some cases, it's narrower. In some cases, it is the same. The learned friend suggests, as to the court below, that, well, a planning obligation is voluntary. In connection with the grant of a planning permission, that is not the case. If the planning authority consider that a planning obligation in certain terms is necessary to enable the planning application scheme to be acceptable, and that obligation is not provided, then it will refuse planning permission.
And you say that condition, that refusal might then be judicially reviewed, and the court would apply the Newbury test in deciding whether the local authority had acted rationally in refusing permission because of the developer wasn't prepared to enter into the 106 agreement.
Yes, my lady, or perhaps more usually it'll be dealt with on an appeal to the
statutory
minister.
planning appeal.
Right.
Normally it would be,
Yes.
but I'll take my lead through the circumstances at the moment. But a planning obligation, where it is being sought in connection with a planning application, is only voluntary in the same way that it's voluntary to buy theatre tickets. You don't have to pay for the ticket, but you don't go to see the play if you don't do so. A developer doesn't oblige to sign up to the planning obligation, but it won't get the planning permission unless a suitable obligation is provided as far as the authority is concerned. But both the situation of planning obligations and planning conditions are subject to what in substance are the same protections. And my lady's referred to one of those already. Firstly, the Newbury tests would apply, both either to the validity of the planning condition or the materiality of the planning obligation to the proposed planning permission. That point made by this court in Wright, paragraph 39, and in Aberdeen, which is quoted in Wright at paragraph 1441. Secondly, they are both subject to policy in terms of those decision making, which in the Secretary of State's case goes in conditions goes beyond the legal Newbury tests. Secretary of State expects conditions to only be required if they are necessary to make the scheme acceptable. In England, that's National Planning Policy Framework, paragraphs 56 and 57. A similar requirement of necessity is brought in for planning obligations to be relied upon for the grant of planning permission in the Community Infrastructure Levy Regulations, Regulation 122, which we've referred to. Then, if the local authority either imposes a condition which the developer considers to be unreasonable, or refuses to grant planning permission because the developer hasn't entered into a satisfactory planning obligation, the applicant for permission may appeal to the Secretary of State, either against the refusal of planning permission or against the grant of planning permission subject to conditions, or the other alternative in respect of a planning permission being granted but subject to a condition which the developer is not prepared to live with. The developer will then make a second application usually under section 73 of the Act for another planning permission subject to different conditions, and will then appeal if they don't get a satisfactory result there. But by those routes, a developer who is subject to what they consider to be an excessive requirement by whether by proposed obligation or condition, can appeal to the Secretary of State. And the Secretary of State and his inspectors will apply, as has been said, Newbury tests and apply the policy approach, which is stricter. If the inspector or Secretary of State's decision is considered unlawful by the developer, they may then challenge that in the High Court, including on the Newbury basis. So in both situations there is protection against abuse. And it's also worth having in mind that planning conditions only come in force when the permission is implemented. And usually planning obligations only have to be complied with. It'll say in the obligation itself, but when the development takes place or at a certain stage. So ultimately, if a developer is not prepared to live with what is expected of them or can't afford to do that, they can simply not carry out the development. The next matter I want to deal with under issue 1 is the question of alternative routes, and perhaps that's, in a sense, to a degree, at the heart of the reasoning in Hall and Shoreham, the suggestion, well, there ought to be compulsory purchase. That, of course, depends on what the reason for the scheme is. Is it the public authorities who want a road for good public general purposes, or is it required by the development? If it's required by the development, then there's no reason why the public authorities should be expected to use their powers to compensate and to acquire the land and to compensate the developer for the acquisition of that land and for the purpose of facilitating the development. It also would do, as I've said earlier, leave the developer at the mercy of when the highway authorities and whether the highway authorities choose to carry out the scheme. What happens in practice is that the developer, if a highway is required or highway improvements are required by their scheme, will pay for it. If it's on their site, they're likely to do the works themselves. If it's off the site, they will come to an agreement with the highway authority to do either to get the authority to do the works and the developer would pay, or for the highway authority to allow the developer to use their contractors to carry out the works. It reflects the point which Lord Hoffman makes in Tesco of the external costs of development and the expectation that those fall on the developer. Whether they do fall, whether they should fall, how far they should fall, is a matter for a fact-by-fact consideration, not for the erection of a principle that a condition cannot require the dedication of a highway.
But ordinarily, what one's talking about external costs which are generated by the development itself. It might be an additional burden on the sewerage system or on the schools or on the roads that might then necessitate, for example, an upgrading of sewerage or the construction of a roundabout in order to accommodate additional traffic. But here, the argument isn't that the development is generating an external cost that's going to have to be paid for by somebody, but rather that you want the developer to essentially confer a benefit on which a council regards as desirable, but which isn't required for the developer's purposes.
My Lord, it's required to make the development acceptable, and that's to deal with the questions of accessibility.
Well, that can't be the test. I mean, in Elsick, for example, if a contribution to improvement works to bridges and roads far from the site were regarded as necessary by the planning authority, but that wasn't the end of the matter.
Well, my Lord, in this case, to render the commercial development on the Symmetry scheme acceptable.
Well, acceptable to whom? I mean, the developer doesn't need public roads on the site. You're requiring him to do it because the planning authority want public roads in order to facilitate connectivity with other sites.
Well, what the developer needs is to have a scheme that is workable in terms of what it will achieve. Part of that is in terms of how you get on and off the site. And that involves, and that's all part of the transport assessment, all part of the contributions made, access in 3 directions once the new eastern villages are complete. It involves the ability to be acceptable for people who are living in the new development in those villages to have access from several directions. What it is not about is both the developer throwing all their traffic through one access onto the A420. Of course, that will be the case until the rest of the development comes into place. But the ability to move between those, part of that in terms of good planning, as my Lord does identify, is that facilitates the remainder of the development being properly connected. But that is part of what is an acceptable development. A corollary of that is that the Symmetry site, the people who work there, the Amazon vans shuttling to and from the Amazon warehouse, it's now on one of the plots there, are then able to use the road network which is going to be constructed in the rest of the new eastern villages to do that. There's reciprocity within it, and there is good planning, and there's a matter of judgment as to where the responsibilities lay for doing parts of that. All of that judgment is one that's within the question of rationality on a case-by-case basis.
Is the reciprocity built into the documents granting this planning permission? I mean, is there somewhere where the council states that it will require those developing the adjacent areas into the new villages will also be required to dedicate their access roads so that people from the Symmetry site can get to those sites or go through those sites?
My lady, it's not contained in the Symmetry planning permission or the Symmetry planning obligations. It's picked. One of the ways in which it is dealt with is picked up in the appeal inspector's report in respect of Lockmead Farm, which was two proposed villages to the south, and there it was being dealt with, as I understand it, because of the issues with this condition. It's page 433 of the bundle, paragraph 29 of the appeal inspector's decision, which refers to a signed S106, a signed planning obligation in respect of Lockmead Farm, which required dedication and adoption of highways within that scheme. That's not actually as an aside, that was in respect of an application which was subsequently refused, but a new planning permission has been granted for the Lockmead scheme. So there a planning obligation was going to be used to require highways to be provided, and going further than condition 39, highways to be adopted in doing that. The point I would make in respect of that, of course, is that it was considered to be a material consideration that highways would be provided, but the 106 in that case would secure it. Going to the discussion which we've just had, it's an illustration of the rationality in public law terms of requiring the provision of highways in the sort of situation we have here of very large-scale development in the countryside, with land being under the control of different developers on different plots. But that what is essential is the provision of integrated, not simply integrated development, which sort of sounds a bit sort of mechanistic, but integrated communities. the ability to people to get around where they live.
So at the same time as you, or roughly the same time as using condition 39 in respect of symmetry, Council used the section 106 agreement in respect of a nearby site. Is that what happened?
It was used, I think we don't have the timings in the particular documents. The Lockmead 106 came after the symmetry condition, and my instructions are that a lot of what prompted the use of a 106 in that case was actually that we're having the difficulties with the condition in respect of the symmetry site. But, my Lord, either mechanism could be used.
Yes.
The fact that you could do something by an obligation doesn't mean you can't do it by condition, and of course vice versa.
It's surprising perhaps to standing the well-known existence of the Hall decision. It's surprising to have sought to have used a planning condition.
Well,
when I think it's a matter of agreement of all parties that a section 106 obligation would achieve the desirable end.
well, my Lord, of course, the question of what the intentions were, what was in people's minds when the conditions are drafted, doesn't. Not something we can go into.
It's more relevant to issue 2.
But my Lord, what is the position is that no one envisaged the difficulty. The committee report, which I referred to, emphasised the requirements of connectivity. Now, of course, is not secured if what could simply happen is the developer could simply stop people getting on. The planning application documents themselves, the illustrative landscape master plan show the road going up to the boundary. The design access statement addendum 2 says these are highways, it's going to the adjoining site. So what was being put forward were highways in those situations. What had not been envisaged was then a dispute about the effectiveness of condition 39 to secure whether there were highways, and that dispute, of course, arose as it was put in terms of an interpretation argument. It now turns rather more on question what the lawful scope of it would be. The reason, perhaps, to take my Lord's point out my Lord's question, why Hall has not really been analysed by the courts is that, as Lord Hoffman identified, these issues have tended to be dealt with by obligations rather than by conditions. We have a situation here where the issue is dealt with by condition. The question is the lawfulness of doing so, which bears then onto what this condition actually means.
Well, what was it that prompted the inclusion? The Section 106 agreement in this case, was that negotiated at about the same time as the planning conditions?
The section, as my lady asked about Section 106 agreement in respect of symmetry, or
yes,
in respect of symmetry, that would have been negotiated at the same time. My lady's right.
Why was it that that Section 106 agreement included reimposed or the same, you say, the same obligation as the same requirement as was included in the condition? Why was there that sort of
my lady, it didn't quite do the same. The Section 106 agreement has two provisions. In respect of the access roads, it's in terms of construction by a certain time and doesn't deal, as has been identified, but is very much common ground of use. In respect of the A420 junction works, that is additional land for the enlargement of an existing adopted highway.
Can we have a look at the 106? clause 3, I think.
Yes, it is. It's a document that starts at bundle page 301. And the first points to pick up are at 304 in terms of definitions. Definitions at the top, towards the top of that A420 improvements, which is the works of the A420 corridor. Then I've mentioned, so we may pick it up at 305, the definition of contributions, including the Southern Connector Road and then various other junctions, which are dealt with.
I'm looking at page 315.
So in terms of the spine road and the north-south.
Yes, that's the roads we're talking about, isn't it?
Those are the access roads within the
The owner's
site.
covenant with the council that within a year they will construct these in accordance with condition 39 of the planning permission. So what's the practical effect of including something that's already a planning condition in the Section 106 agreement? That's what I'm asking.
Yes. The practical effect is in relation to the timing of the construction of the roads up to the eastern and southern boundaries. Because if we have in mind condition 39, so each unit is served by a fully functional highway. At present, until the rest of the new eastern villages are constructed, or those immediately adjacent parts are constructed, each unit will be served by fully functional highway by the relevant part of the access road going up to the A420 until such point as the other routes are joined in which case the requirement to serve by fully functional highway applies to the east and the south connections. What the planning obligation does at Schedule 2, Clause 3, Schedule 2, Paragraph 3, is to require the full extent of the east-west and the north-south links to be constructed by a certain time, even if that is in advance of the adjacent development which would provide the highways which would link into those. So it does give those degrees of deadline. I'm not sure if Lord Sales was trying to say anything, but shake of the head, I'm grateful. And what 314, 315, the A420 improvements do is to provide for some of the land to be made available for improvement work to the existing adopted highway, so the existing A420 to the north of the site. And in relation to that explanation of the control over the development of that part of the land for a transfer in relation to it. Absolutely no dispute, of course, that provision of land for nominal consideration for the improvement of the A420 was rational within that obligation. Can I then move on to the final point on issue 1, which is a new point raised by the Secretary of State in relation to the European Convention on Human Rights, not a point which is taken previously. Refers to a Polish decision called something like that, at page 1262. I draw attention to...
Page 12?
Page 1264.
Thank you.
But I draw attention to... It seems to be that the Polish situation involved larger roads being constructed by public authorities and for the authorities to take those lands. The dispute was the authority not taking on that particular land. But it's worth having in mind, I'll say more in reply to how my learned friends put it, having in mind the comments of Lord Carmouth in this court in Cusack, page 648, paragraphs 39 to 44, where he suggests at paragraph 44 that the case was a somewhat extreme example of the use of the first protocol to override the decisions of the national authorities. It is, as is often the case with Article 1, Protocol 1 cases, a matter of whether the restriction on the use of land is in the public interest. And that goes ultimately, in reality, to the rationality points which arise, and that it is not for the public authorities to have to go to the trouble of building roads which make a developer's scheme acceptable. But if there's more said, I'll deal with the ECHR point further in reply. Can I then turn to issue 2 on interpretation? And what we say on interpretation is, first of all, if we succeed on issue 1, then there is no difficulty that condition 39 requires the dedication of highways and is lawful. If we fail on issue 1, so a condition requiring the dedication of highways is unlawful, then it is still the position that this condition would require the dedication of highways. It would just lead to the permission itself falling. I'll deal with that very, very briefly at the end on issue 3. But in terms of interpretation, the law has been set very clearly by this court recently in Lambeth. In particular, paragraph 19, which is at page 1991, where Lord Carnworth said, whatever the legal character of the document in question, the starting point and usually the end point is to find the natural and ordinary meaning of the words there used, viewed in their particular context, statutory or otherwise, and in the light of common sense. He emphasised at paragraph 28 that a reasonable reader should be assumed to start by taking the document at face value before being driven to an elaborate process of legal and contextual analysis, which is what the Court of Appeal had done in that case. Now, in Lambeth, the Court of Appeal had incorrectly interpreted a planning permission through the prism of Section 73 of the Town and Country Planning Act. And as the court may recall from that case, that grants a planning permission for the same description development as a previous permission, but subject to different conditions. The problem, what you ought to do if you're doing it properly, is to make clear that it's a new planning permission and you apply in that planning permission all the existing conditions that are still relevant. That's not what the Lambeth document had done. The Lambeth document had referred to it being a variation of conditions And the Court of Appeal's analysis, which said that the previous conditions had not applied, was, the Supreme Court said, elaborate, but based on essentially the correct legal reading of Section 73, that it's a new permission. What the Supreme Court said in Lambeth was, well, actually, you start by reading what actually the document is saying, without reading it through a detailed prism of the law to do that. Taking us to the situation we have here, the planning permission is to be read as it stands, with the documents incorporated in it, which include the illustrative landscape master plan, which is referred to in conditions 3 and 50, and the design and access statement addendum 2, which is also incorporated by condition 50. The planning permission requires the dedication of the access roads as highway for the reasons, and the highway being a public right-of-way along them, for the reasons which are given by Mrs. Justice Andrews in the High Court. Her analysis on that, which I simply at this stage I can headline and summarise, because it is, I suggest, impeccable and clear on this point, has these elements. First of all, that highway, which is the language used in 39 and used in the design access statement, means a way over which the public have a right of passage. And she relied specifically in that in respect of the Transport for London decision of this court, paragraph 6, which is at page 197, and paragraph 32, which is at 1205. Whilst sometimes highway may be debated as whether you're discussing simply the ride, or you're discussing the physical extent of it, how far it goes up and down, what the makeup of it is, and so on, what is integral to highway in all the cases is that it is a public right-of-way over it. The legal dictionaries are contained in the authorities that set out in Mrs. Justice Andrews' analysis from paragraph 54 onwards, page 252. The second point is that the Town and Country Planning Act applies the Highways Act definitions of highway and also bridleway and footpath. So, of course, as in all these things, unless the context otherwise requires, and again, unless the context otherwise requires, you presume that words in a planning document will bear the meaning which they have in planning law. That's the Wyre Forest decision of the House of Lords, which is referenced in the Court of Appeal, in this case at paragraph 66. So the references to highway and also the references in the illustrative landscape master plan to carriageways and so on are, we're expecting context to be understood by how those terms are used in the legislation. Then we turn, point 3, to condition 39 itself, and what that requires in respect to the areas that serve necessary highways purpose shall be constructed in such a manner as to ensure that each unit is served by fully functional highway. So it's not simply about construction, but it is about ensuring each unit, so each unit on the development site, is served by fully functional highway. A highway there being a way which the public have a right over, is served, meaning not simply the physical construction of a route, but the right to use it as a highway. It's not served by a highway if there is a road, but one which people do not have the highway rights to use. That works in the context of the repeated references to highways and to highway safety throughout that document. There are the references, including in the reason to condition 39, to public highway. That is best understood, as Mrs. Justice Andrews identified at her paragraph 72, as a reference to adopted highway. May in some circumstances simply be tautologous and casual, but works as giving an access for each unit to be served by fully functional highway, not the site being served by fully functional highway, but each unit, which is the employment units within the site, and which go off those by going onto the access roads. And for that to be served by fully functional highway, it's the access roads which are being talked about, and it is to make those available as highways.
By the access roads, you mean what's been called the east-west spine and the north-south?
The east-west and the north-south. Lady, what road network there is within the particular development parcels themselves is not a matter that's required to be highway as one might expect. It's the north, south, east, west links, and that is to be. The condition 39 is to be understood, having looked at the incorporated documents, which include the illustrative landscape master plan and the design access.
Give us those references to those incorporated documents. Particularly, I think you said earlier that in one of those, the developer did indicate that it was their intention that these roads should be highways.
Yes, my lady. The illustrative landscape master plan is at page 258.
Yes, we've seen that one before.
Well, I'm sure I've looked at what that particularly. What I pick up within that is where simply the scale of what's proposed, but also the under, for example, north-south access road, dual carriageway, and we've got references to carriageways and bottom left to strategic footpath.
And can I ask, are the areas marked here as A and B, the areas referred to in the 106 agreement?
Yes, they are, my lord, in terms of the timings of the provisions of the road.
Yep.
And so the units which are referred to in condition 39 will be units which are to be constructed within areas A and B. Yep. As what's happened on site is that most of the things have been built out. Area A is taken by Iceland, the food retailer, the present food retailer. Area B has an Amazon distribution warehouse on it. And so what condition 39 is requiring is that the units within the areas are served by fully functional highway. That's in the context of, it says, the proposed access roads.
And what was the other document that you said is incorporated?
The other document is, my lady, fine, starting at the page 259, which is headline there, DAS Addendum number 2. DAS is Design and Access Statement. And for a planning application, a major planning application, you have to put in the design and access statement explaining, amongst other things, how access to and within the site is to be carried out. This is the Design Access Statement Addendum 2, and it relates to the illustrative master plan which we've just looked at. And if my lady goes to page 260 within that, paragraph 4 has the east-west and north-south access. And the applicant tells us that the illustrative master plan, we see another copy of that on that page, has also been amended to show highways extending to the site boundaries. This amendment is made to show the connectivity of the site to surrounding land and then said to be consistent with other documents. Remember that paragraph, these show the east-west route and north-south route extending through the site and into adjoining land. So the developer is saying that these are highways, and it's to show connectivity. There's that recognition in the application. It's not something that the local authority imposes for the first time in the permission, but in the application, by the time we get to various revisions, a recognition that there need to be highways going off the site in 3 directions, and that's part of the connectivity that's required, and that's what condition 39 is securing. Finally, in respect to Mrs. Justice Andrews' analysis, she says at paragraph 65, page 253, that this was never intended as a cul-de-sac business estate. And she was absolutely right in how she interprets the planning permission, that it was never intended in such a way. That is, though, the effect of the interpretation of the condition, which is given by the Court of Appeal and urged on to court by my learned friends. That whether there is any other accessibility to the east or the south is not determined by the planning permission, but determined by whether or not the developer and Symmetry have hung on to the roads even though the main sites have been disposed of, whether the developer chooses to do a deal, and if so, on what terms, with somebody else. And that does not secure connectivity, which is what that permission does do. Can I turn then finally on issue 2 to the validity principle? And that applies if there are 2 or more possible interpretations, and one of the interpretations would render the document unlawful. If in that case, then a lawful but realistic interpretation is to be preferred. Now, the validity principle only applies if the natural interpretation of the document would be unlawful. So if we succeed on issue 1, the validity principle has no application, because on any interpretation, condition 39 is not unlawful. The Secretary of State urges a different approach to the validity principle as we follow it, which is that regardless, the Secretary of State tells us, of whether they lose on issue 1, the permission should be interpreted on the basis that subjectively the drafters of the document took the incorrect view that it would be unlawful to require a highway. Now, that is a wholly wrong approach. The validity principle discussed in Tillman, but also in a sense it comes through, as the Court of Appeal pointed out, through some of the earlier planning cases. You prefer a lawful interpretation of a document to an unlawful interpretation of a document. That's about whether or not a particular interpretation would be unlawful. It's not about imagining yourself in the minds of one or other of the participants in the drafting of the document as to what they would have sought to have avoided on the basis of what their understanding of the law was at the time. That is, as urged, a wholly subjective exercise, an exercise, in fact, based not simply subjectively, but without evidence to it, and which a reader of the document would not know what was in the minds of those involved. So the validity principle here only applies if we lose on ground one. The question then would be whether there was a realistic interpretation of Condition 39 which would render the permission lawful. That is not open in this case to the court, because Condition 39 is served by fully functional highway in the context of the incorporated documents, the Landscape Master Plan and the Design Access Statement, both of which, as I said, are identified in conditions in the permission, requires the dedication of highways. Mrs. Justice Andrews, point picked up by my learned friends, said that the inspector's interpretation of Condition 39 was possible, but when looked at in isolation, and that's paragraph 63 of her judgment, page 253, when you look at the documents together, which are part of the permission, it is not possible to interpret the permission as not requiring the dedication of highways. And so that's not, in any event, a realistic interpretation. I would add finally on the interpretation point that being served by fully functional highways, or fully functional highway is the language, not Court of Appeal put it, a highway, it's a fully functional highway, requires highways in the three directions once those are available. Mrs. Justice Andrews is quite right about that at her paragraph 73, and that's a conclusion that comes from doing the exercise which we've just done of looking at the Illustrative Landscape Master Plan and the Design Access Statement Addendum number 2, which makes very clear that that is what is intended. The final issue is issue 3, which I can deal with incredibly briefly, which is what is the consequence if we fail on issue 1, so it's unlawful to have a condition requiring a highway, but the meaning of Condition 39 is that a highway is required. The consequence would be that the planning permission would be invalid. That is a point which I did pick up because of one or two comments. That's a point we have made from the start of the proceedings. Paragraph, the Statement of Facts and Grounds, page 454, paragraph 67. It was a point accepted by the High Court, paragraph 35, page 248. The Court of Appeal said the permission would be probably invalid if the condition was invalid, paragraphs 52 and 72.
Is this an issue we have jurisdiction to deal with? We're dealing, the proceedings are a statutory review of the Council's refusal of a certificate of lawful development. So if you, in a scenario you're envisaging, the Council would have been correct to refuse the certificate? If section 39 requires a highway, then you're envisaging also that you fail on issue 1, so it's unlawful to require a highway.
Yes.
But section 39 required one.
Then, my lord, in that case, which is certainly not our primary case, it's certainly not the result we're after. I should emphasise the result would be that the planning permission falls.
Well, we can't set aside the planning permission, can we, on a certificate, on an LDC appeal?
Ultimately, it came to it, we could, because the issue of the lawfulness of a planning condition, the lawfulness of a permission may arise in later proceedings. So that's the case in Newbury, which concerned the lawfulness of a planning condition, and then discussed further in the Dill case most recently by this court in terms of a challenge to, in that case, the lawfulness of listing of a building, or what may or not be a building. The outcome in Hall was that the condition was found to be unlawful, and so the whole permission was found to be unlawful because the condition was important to the permission. And that's also a consequence in another Court of Appeal decision called Pedgriff.
Yes.
So,
but they would be statutory appeals against the grant of planning permission subject to the conditions. I imagine. I haven't checked the cases, but I imagine that's what they were.
Well, Hall was a direct challenge. At Pedgriff, the issue arose several decades after the permission had been granted. That would have the consequence that the certificate falls because there's no planning permission.
So if a condition is successfully challenged, there's then an issue of severability, and if it's not severable, then the condition has to be, then the planning permission.
Yes, my lord. That's the point. That was accepted.
It is invalidated.
Yes.
I'm just wondering about whether we can go that far in an appeal of a present kind, or whether the correct answer is that you weren't entitled to issue a certificate of lawful development, to refuse a certificate of lawful development, but you would be. Well, would you have to try to set aside the planning permission that you granted?
Well, we'd be entitled to refuse a certificate because the certificate is based on there being a planning permission with a valid condition.
Yeah, but isn't the permission? Yeah. But the permission authorises development so long as the permission is still standing.
Well, the permission, but part of, if Condition 39 was seeking to require the provision of highways for reasons what one takes to be, the underlying reason to be important, but it is unlawful to do it, then my Lord's point of severability,
well, I understand
then the whole thing falls. Now, my Lord, make the point very clear, this is very much, and never has been, what the council either thinks the position is or wants the position to be. I can, recognising the late start, I can shave a few minutes off, but my Lord, the council's primary position is, as I hope I've been able to explain to the court, that the lawfulness of a planning condition goes to the Newbury tests. That is a fact-by-fact situation. There isn't a general principle that you can't have a condition requiring a highway. Council decided that was what the condition should do. Rational to do that. You don't need to go any further than that point. And so when it comes to interpreting the planning permission, Condition 39 requires each unit to be served by fully functional highway, and so that the access roads are to be highways. For those reasons, the inspector's interpretation of the planning permission was incorrect, as was the interpretation taken by the Court of Appeal, the interpretation of Mrs. Justice Andrews in the High Court was correct, and so the inspector's decision should be quashed, and the appeal then to be remitted to the Secretary of State.
I'm just this is a statutory procedure under Section 288 of the Planning Act, isn't it? I'm just looking at Section 288. I don't think it's in our bundle, but I've brought it up myself on my own machine.
It's a power. It's a power to quash.
Yeah.
So I said remission.
It's a power to quash the decision
of the inspector
under review, which is the refusal to grant the certificate.
Well, it quashes the inspector's grant of the certificate in respect of that appeal.
Ah, yes.
Right. So it will then, I say remit. It doesn't strictly, the 288 doesn't order remission, but what Section 288, the order of the court, would be to quash the appeal decision. In practice, what then happens, the jurisdiction to determine the appeal reverts to the Secretary of State, and if the appeal is still to be pursued by the appellant, Symmetry in that case, in the light of the court's judgment, then the Secretary of State or one of his inspectors will have to redetermine the appeal. So the order would simply be a quashing order.
Yeah. And so you would be asking us to quash on the scenario that you fail on the first issue but succeed on the second, you would be asking us to quash the inspector's decision on the footing that her decision that you should have granted the certificate of lawful development was unlawful by reason of her failure to appreciate that condition 39 was, in the first place, an unlawful condition, and secondly, so vital to the planning permission that its unlawfulness vitiated the planning permission.
Yes, my lord.
That's what it comes.
Yeah, my lord. That's the secondary point. But of course, what we identify is that this is a lawful condition. The Newbury tests are to be applied, and they apply in.
So if it's a lawful condition, then it was still wrong for her to issue the certificate of lawful development.
Yes, my lady, because what she should have found was that condition 39 required the dedication of highways. So the certificate application, which was to have a certificate saying we don't have to allow the public on, was ill-founded.
So really, all possible outcomes result in your success. Whether you win or lose on issue 1 and win or lose on issue 2, one way or another, she was.
well, my lord, if the conclusion of the court was that the interpretation of condition 39 was it did not require the dedication of highways, then I would lose on. Then I would lose. But. We say it does require dedication of highways.
Okay.
And that is a proper application of the Newbury approach on a case-by-case basis. And the error of the Court of Appeal in Hall was to at least frame their reasoning as a point of principle about conditions requiring highways, rather than to analyse the justification for a highway or the equivalent on a case-by-case basis. So for those reasons,
even if it is permissible to include a condition requiring the dedication of a highway, there is still the question as to whether Condition 39 actually does that on its wording.
Yes, my lady.
Right, but what I'm not clear about, that we will hear from your learned friend, is whether their case and construction turns on the principle that although it may look as if it means that, it can't, because that would be an unlawful condition, or whether they say Condition 39 on its wording doesn't require the dedication of a highway, even if Hall is wrong or confined to its facts, and it's perfectly possible to impose a planning condition to that extent.
Yes, well, I think my learned friends try, there's a sense, particularly from the Secretary of State, and a different direction from Symmetry, of them seeking not to rely on actually what the Court of Appeal said in Hall and Shoreham, and try and find another way round. But on the basis of our view as to what the law is, then the interpretation necessarily follows in the circumstances that this does require a highway. And that is a sensible and pragmatic position, which is within the judgments the authority could make about how this vital development in part of Swindon should come forward. It facilitates good development. The case-by-case approach to Hall and Shoreham type issues, rather than the erection of a principle, as the Court of Appeal sought to do in that case. But unless I can help the Court any further, those are all my submissions in opening.
Thank you very much indeed, Mr. Howard. Well, Mr. Humphreys, I'm afraid you've been slightly delayed, but you'll understand why.
Of course, my Lord. The Lords, my lady, my learned friend Mr. Honey and I, to my right, have discussed how best to use the time allotted to the two respondents, so far as is possible, to allow as many points to be covered and seek to avoid duplication. There appears to be no material difference between my client's case and that of the Secretary of State for the purposes of this appeal. On that basis, I am able respectfully to adopt his submissions in advance. My learned friend will deal, I envisage, in particular, for example, with the validation principle and the ECHR point, but just to give some outline of where there may be additional points. If I may, I'd wish to make some introductory observations on four matters before addressing the detail of grounds 1 and 2. And the first headline is the standard practice. If, as is asserted, the Appellant Council had wished to ensure that public rights of way were dedicated over the north, south and east-west roads within the application site, the Council could and should have used the legislative machinery provided by Section 106 of the 1990 Act and or Sections 38 and or Section 278 of the Highways Act 1980. That is and has been the standard practice of local planning authorities throughout England for all the time that I've practiced at the bar, some 36 years. I respectfully recognise, of course, that some of your lordships will have yet more experience of planning than I have. One confirmation of this standard practice can be seen in the facts of Thomas and Bridgend County Borough Council in 2012. I don't ask your lordships to turn it up, but if I may, I shall give you the references in the other authorities bundles at beginning at page 2647 at pages 2653 and 2663. That's paragraphs 6 to 7 and 54. That was a decision in which Lord Justice Carnworth, as he then was, gave the leading judgment. And just to give your lordships a feel of it, at paragraph 54, his lordship refers to agreements such as Section 106, Section 38, Section 278, to which there's been reference in paragraph 6 to 7 of his judgment, as a, quotes, familiar feature of the planning of major developments and no doubt he was saying in the context of that case, would have been so in 1973. So that goes back a long way. Of significance too, of course, to our case, is that the inspector herself noted that the council itself was, to use the inspector's own words, obviously aware of the means by which securing the future public availability of land could be properly achieved. And that's at paragraph 31 of her decision letter in the core volumes, page 434. So the council itself was obviously aware of the means by which the securing the future public availability of land could be properly achieved. This was borne out by the fact, as she noted, that in the section 106 obligation entered into the day before the planning permission was issued on the 3rd of June 2015, the council had felt able itself expressly to undertake to dedicate the A420 improvements land in specified circumstances. And that's quite apart from that, of course, is the reference that she makes to the Lottmead Farm decision, which postdated the application, section 106 in that case, postdated the 2015 planning permission in our case. The inspector's decision to grant a certificate certifying the lawfulness of the private use of the access roads in this case was a decision of a very experienced planning inspector. He'd been in post since 1990 and a practicing solicitor in both public and private sectors before that. So in 2018, her decision, that was a very substantial period of time after 1990, and before that, very valuable and relevant experience in public and private sectors as a practicing solicitor. So that's the first headline, the standard practice. Second headline, the position in policy is based on an understanding of the law for more than 70 years. The preface to the 1951 circular issued by the then ministry stated that, and I quote, "The views expressed in it," i.e. the circular, "are not new." So the advice they gave in that 1951 circular, based on understanding of the law and indeed based on previous policy, they were not new points. So we can assume they go back at least until 1948, if not before that. I would also note under this heading, just one brief point in passing, that there is no suggestion in the officer's report to the planning committee that it was intended to depart from long-standing and the then current iteration of government policy, or to depart from well-established law, nor, perhaps again in sub-brackets, was there any consideration of Article 1 of the first protocol, followed by a determination that it would not be infringed. My third observation comes under the heading, the understanding of the law in 2015. I simply say this: the well-known case of Hall was the law as at the date of the grant of planning permission on the 3rd of June 2015. I share the views taken by my old friend Mr. Honey for the Secretary of State, that that is an important aspect in any application of the validation principle, and it also accords with the views of Lord Justice Lewison in the Lambeth case. Obviously that was Court of Appeal authority before it went to Supreme Court. The Supreme Court did not suggest that what he says at page 1973 of the bundle, 1973 paragraph 52, that when one's reading a condition or a permission, or whatever the document is, in planning terms, that one can assume that when the reasonable reader would have some knowledge of planning law and practice and the policy of the government, the national policy that was then in force. And the other point under this heading, the understanding of the law in 2015, that is relevant to ground 2, irrespective of the view that the court takes in respect of ground 1. And I would add, to answer a question from the lady, our position is that even if Hall were to be wrong, then condition 39 does still not require the dedication of public rights of way, or public rights of passage. My fourth and final observation, introductory observation, the headline is condition 39 does not require dedication expressly or impliedly. It's very important just to see the wood from the trees. The appellant does not argue that dedication should be implied, whether from condition 39 or from the permission as a whole. And that was noted by Lord Justice Lewison at paragraph 77 in the court below, and I haven't heard anything differently this morning. There's no suggestion in particular that the condition lacks practical or commercial coherence. It's the phrase used by Lord Justice Lewison in the Lambeth case, again, not departed from, not criticised by the Supreme Court in any way, in terms of whether words should be implied into the condition, that the condition doesn't lack practical or commercial coherence. There is nothing in principle wrong at all with a road, whether it's called private road or has public rights of way, that there's no reason why there cannot be connectivity, visible connectivity with other sites, and it does not require me to, I'm still able to drive my car or my vehicle or walk or bicycle along this road, whether it is given by virtue of dedication of public rights of way or because the landowner has given a license to surrounding landowners to allow them to use that.
Where is the license?
There isn't a license yet in being, but...
And who will be licensed to use the road?
Well, lady, there are a number of possibilities here. There are a number of surrounding landowners and developers, and that will be a matter of negotiation with them. The council may or may not take part, be party to those discussions, but that is something that will take place at the appropriate time. At the moment, until we have the outcome of this decision, obviously views are somewhat entrenched. People don't know what their rights are. This stage, we wait to see.
But realistically, we're not looking at licenses being granted to individuals to go along the road. I mean, what you're talking about is using the fact that you have built this road to negotiate with the other developers a contribution towards your costs, and then agreeing on the dedication of the whole thing and its adoption by the council. That's the commercial reality, isn't it?
That's the commercial reality.
Right, but you can, in theory, stop anyone you want or anyone you don't want going down this road.
Theoretically, yes.
And how do you decide who is to go down the road and not?
Well, lady, there's no suggestion, and I'd certainly there's no suggestion that my clients are intending to prevent anybody from going down the road with a bus user to take another point, which was referred to earlier, or simply because it's a private road. There's no intention. It's simply the commercial arrangement. If negotiations, if there was a failure in some way, a breakdown in those negotiations, then that will have to be addressed, if at all, by the local planning authority in terms of how it proposes to proceed. But there's no suggestion, there's no evidence for before the court, and it's nor in the evidence, that my clients intend to prevent anybody, in principle, from using the road. It's simply, they quite reasonably, it may be said, I know there are always two perspectives, or at least two perspectives. It's quite reasonable for my clients, having put in these very expensive roads, which are serving not only their site but also other sites. We've seen how a lot of the developments, 8,000 houses, they'll be using this access onto the A420 as well as the other two to which reference has been made. Then, in terms of building these roads to the standards they've been built, then is it not reasonable, and asked rhetorically, to seek a contribution towards the costs of their provision and their maintenance? That's the way we put it. And if there were, just by way of background, if only just to support the intentions of my clients, not in terms of interpretation, going to interpretation of the condition, but Mr. Partridge's witness statement sets out quite clearly what the intentions are and what and that is at page 497, the witness statement. Just by way of background, we haven't put in all the exhibits. It's simply there just to provide context. If I can just finish this one final point under this heading. If there were any doubt at all as to the scope of the condition, and it's submitted, there's no real doubt, it's noteworthy that the identical wording of Condition 39, when placed before members of the Planning Committee in the report to committee at page 297, was headed completion to base course before use. Nothing to do with dedication, yet those self-same words with a different heading, roads, then said, although Condition 39 when presented to committee had nothing to do with dedication, it now suddenly has something to do with dedication. And so with that, Lord Lady, I hope that's a convenient moment.
Yes, thank you very much, Mr. Humphreys. We'll adjourn now and resume at 2 o'clock.